We are often asked, why should I appoint an attorney when we're helping our clients with their wills? This isn't just an American term for a solicitor. In this video, I'm going to explain the two types of attorney in Scotland and why they are useful to put in place when writing your will. I'm Douglas Crombie, a solicitor at Raeburn, Christie, Clark and Wallace. You may find the following information useful when considering your own circumstances, who you may want to be your attorney, which type of attorney you'd like them to be, or if you've been asked to be an attorney, whether you want to take on the role. When writing a will, your solicitor may also ask you if you want to appoint an attorney. This is someone you appoint to make decisions and manage your affairs on your behalf, where illness or injury prevents you from doing so personally. In Scotland, there are two types of power of attorney: a continuing or financial power of attorney, and a welfare power of attorney. You can put either one or both of these in place. When considering a power of attorney, we normally recommend putting both types of power of attorney in place as part of planning your personal affairs, giving both you and your family peace of mind. If you implement a power of attorney, what powers does your attorney have? Essentially, your attorney can act as if they were you. If given financial power, they can, for example, manage your bank accounts, sell your property, look after your investments, and oversee your business in your place. If given welfare power, they deal with your day-to-day welfare and healthcare, for example, by consenting or refusing medical treatment and deciding where you will live. The attorney can only start to act on your behalf in a welfare capacity when a doctor certifies you are no longer capable of making those decisions yourself. However, if you consent to them acting on your behalf in financial matters, they can do so any time after the document is in place. As their powers are wide-ranging, you must have absolute trust that those you appoint will act with your best interests in mind. You should consider appointing more than one attorney so they can assume the role together, or have someone as a substitute who can step in should the first named person be unable to act. There are safeguards when appointing an attorney. A solicitor or a medical professional must meet with you when you sign the document to certify that you have the capacity to do so and you are not being unduly influenced. Before being used, the power of attorney has to be registered with the Office of the Public Guardian, who can supervise attorneys and investigate complaints regarding their actions. The law also contains guiding principles an attorney must follow, and there's a code of practice they should adhere to. In summary, an attorney makes decisions on your behalf when you are unable to do so due to incapacity. They can act in a financial or welfare capacity or both, and there are safeguards in place to ensure they act with your best interests in mind. An attorney can only be appointed following a meeting with a solicitor or a medical professional and must be registered with the Office of the Public Guardian. To find out more about planning your affairs, you may want to watch our video on things to consider when planning a will here. To start a conversation with one of our knowledgeable and friendly solicitors about why a power of attorney may be appropriate for you, simply follow the link in the description below to fill out a contact form, and we'll contact you to discuss your requirements further.